General Spangler, I don't know that we gave you the benefit of any further opportunity to respond about that judicial notice issue. Counsel has departed. We'll take your concern about whether you need any more of a response when we dispose of the case.
Thank you, Your Honor. Appreciate it. Okay. I think I said all I needed to say anyway, so I'm content. Thank you.
All right. All right. Call the next case.
State of Tennessee versus Geoffrey and Paschel.
Good morning, Your Honors. May it please the court. My name is Jeff Witt, and along with co-counsel Richard Gaines, we represent the appellant here, Mr. Geoffrey Paschel, who was represented at trial by Mr. Isaacs, but Mr. Gaines and I are handling the appeal. For the record, I would like to reserve 7 minutes. 7 minutes. Which is, I realize a little bit more than usual for rebuttal. Your Honors, we have a judge across the street who every day when it comes time to tell the defendants about the rights, he says this every time: your most important right is your right to a jury trial. That's your most important right. And I agree with that. I think it is an important right because it's a distinction of our system. But as we go through that, we learn that it's not just a trial, it must be a fair trial. It must be a trial that is based upon that and follows the rules that we have, and the constitutional protections that we have. And in this case, this defendant, Mr. Paschel, did not receive the benefit of a fair trial. There were issues, and there's going to be two major issues that I'm going to be talking about and using an overwhelming majority of my time. But the issues that happened in this trial leave us with the inescapable conclusion that this was not a fair trial. This was a short trial. This was basically a 4-witness trial that went into a second day. And there was an error on day 1 and there was an error on day 2. And both of these were insurmountable as it applied to the defense in this case. The first one that we're going to talk about that we included in a brief is Officer Johnson, who was the officer that went to the scene of this particular case. He goes and he testifies on day 1 about things that he observed, meeting with the victim. Then he goes and he meets with the defendant. And then during the testimony at trial, he's starting to talk about certain cuts and bruises that might have been on the defendant. As he's starting to do that, trial counsel realizes he's getting ready to go into something that was on the video. And that is the issue that the marks that were on the defendant were self-inflicted. This had come up already in the redaction video portion. And the judge at that time had ruled that that would not be admissible, and basically because of hearsay was the initial thing that the trial court ruled. So they approached the bench, with the witness still there. They approach the bench, and Mr. Isaac's concern is he wants to get this in, and we believe under 401 and 403, he says it would not be relevant and it would be prejudicial. And then he goes on to make a 701 argument. He doesn't cite the rule, but he says, plus they've not laid any foundation. We don't know, he doesn't have any expertise. This is something for an expert. All we know is that the judge does not make any specific findings other than to make the instruction, well, refers to the state and says, ask your question in a different manner. Now, an important thing that we also know, and we know this from the record of the motion for new trial, is that we know that the Officer Johnson, was instructed not to do that. And not to go into the fact that these were about these wounds. We know that because on page 7 of the motion for new trial, Mr. Isaac says that the court at the bench conference admonished Officer Johnson not to go into that opinion. And then the prosecutor on page 20 of the motion for new trial says the court did tell Officer Johnson not to go into that. And the first thing that the officer said when the prosecutor asked to describe the injuries, he says they were self-inflicted. This is a huge, huge error. It is a huge, hugely impactful error, because now all of a sudden this defendant with this defense has now been told by what's supposed to be a neutral witness. An officer is supposed to come in, they're trusted, they're supposed to come in as a neutral witness, has given a lay opinion about an expert issue that his wounds were self-inflicted. And if his wounds were self-inflicted, that means his credibility is shot. That means he's lying. That's what that means. We've all that's been in the trial courtroom, we know that credibility means everything.
Did the jury see photographic evidence of these scratches on the defendant?
Yes.
Okay.
And the officer didn't testify, as you just stated, they were self-inflicted. He said they looked like they were self-inflicted. Am I wrong about that?
Well, no, I don't think you're wrong. I don't think the distinction, either way, there's no way that a reasonable person can hear that, the semantics of her, and I don't mean to minimize what you're saying, but I'm not trying to maximize that. I was trying to say it another way either.
Okay.
However, there's no way that a reasonable juror could not listen to that and not think that this officer felt like these wounds were self-inflicted.
Although the trial judge instructed him, did he not? Didn't he instruct them to disregard it?
And he did do that, and he told him, and he told him to pretend. I think the words that the court instructed the jury to pretend this did not occur and to not consider it. I don't know how you do that. In the vineyards of justice that we're laboring in from day to day, I don't know how you do that. I've never known how you do that. I realize we have to have the rules and they have to have accommodations for things that happen, but I don't know how you do that. And in something, so we have to look at how important that issue is in this particular trial, four-witness trial, where credibility is everything. This is a he said, she said trial. If there ever was one, this is one.
Mr. Witt, why are you so certain that it's not admissible under 701?
Well, first of all, let's go back. First of all, there was no foundation laid. We know that there has to be, under 701, you have to have some sort of knowledge and foundation that you have some sort of expertise or some sort of knowledge.
I mean, under 701, so lay opinion testimony.
Right.
It's rationally based upon the perception of the witness. As Judge Easter indicated, I thought the testimony is that the wounds looked like they were self-inflicted. That seems to be opinion evidence that's based upon his perception.
I don't think that it is. I think that under the state, I know they cite the State v. Samuel, where it talks about the issue of wounds that occurred. They were, I believe, scratches or whatever, as far as when they actually occurred, right. Whether they were fresh or not. That's one thing. That's lay opinion. But this is something different.
What about this? This court has upheld, for example, lay opinion testimony when a witness testified at trial that a particular bruise looked like a handprint. And this court rejected the notion that that was called for expert testimony because it was rationally based upon the perception of the witness and was helpful to the trier of fact. How is this testimony any different from what was at issue in Bishop?
Well, you're talking about a much more complex setting than I think than a bruise. You're talking about making an opinion as to who, not what happened or what were created, but who actually even made those scratch marks. And talking about where's the foundation laid, even under 701. And I know an opinion that I believe Judge Witt was involved in back from 2001, the State v. Everett, where Judge Jerry Smith had wrote about this very issue. And
the officer here, though, went into the reasons why he believed that it was a self-inflicted wound, did he not?
Well, I think he went through what he was observing, what he was observing, but I don't think that he had the expertise at all or the experience at all to be able to give what we believe clearly would require a more knowledge, more advanced knowledge than a lay opinion would be able to give him in that circumstance. He did not have that. He did not have the ability, and obviously he was also, and let's don't lose sight of the fact, he was instructed by the trial court not to do it.
On what basis did that occur? So I understand in the motion for new trial, both the prosecutor and defense counsel referenced a previous ruling of the court that the officer should not testify in that regard. On what basis did the trial court restrict the officer?
Well, all we know is we have to go by the record, and what we know is that he did restrict him based upon the arguments that were made at the jury out hearing, or I don't know if the jury was out or not. I mean, but anyway, at the bench conference, and that was that counsel, Mr. Isaacs, said 401 problem, 403 problem, both which I agree. The 403 clearly would have been an issue. He advanced that argument, and then advanced what I think was a 701 ruling. And
you had mentioned a hearsay issue, though, because the statement was also contained on a video.
yes.
Was the hearsay reason the court kept it out initially?
No, that's not why they were keeping it out. That was on the redaction issue. That was on to redact that from the video at the time. But he specifically reserved the right to eventually rule, which he did. He made no findings on there, the trial court did not, as to why he instructed that. We just know what the arguments were advanced, and we know what the result was. That's all the record indicates. The second issue, which occurred on day 2, was perhaps even more egregious, if that's possible, in that when the victim was testifying as rebuttal witness, she came back in again, and in the process of talking about her phone, she then utters out the fact, when asked by the state a question about what was erased from her phone, she reveals, well, I don't think I should be, I think what's basically, I'm trying to look at the specific quote, that she probably shouldn't do this. But she goes ahead and says there were pictures of when this had happened previously, and that in reference to injuries that she might have had.
You're down to your reserved time, Mr. Whitt, if you want to use some of that.
I'm going to use about 2 more quick minutes. What we know is, once again, that she was told not to do this. The state had advised, and the prosecutor had said, I told her, you cannot, and we will not talk about things that happened, and told her, yes, told her again during the trial that we cannot do this, and yet she muttered it out anyway.
Was there a 404B hearing on any of this?
No, because none of it was ever, there was 404B given, but not on this particular defendant with this particular issue. So there was no way in advance, obviously, that there was any going through the process of 404B to determine its admissibility. So it was blurted out. So once again, second attack on the credibility of the defendant. And there's no way to unring the bell. There's no way to pretend that you didn't hear it. There was no way to do that.
Well, the trial court made a finding that was not unreasonable, that if they're looking at the victim's credibility, either they believe her or they don't, and what she said about a prior instance would also be covered by that fact finding.
It would, and the court in that statement also said, I think the prejudicial effect is lessened here because of that, but it's not that it doesn't exist. The court felt that it was lessened. But here's where I think it ties back into it. It ties back into it because the jury's being asked to make a credibility call, as the judge correctly pointed out. He said her credibility is still open, but This was the very end of the trial. This was right before closing arguments. This was the very end of the trial. So when the court says her credibility is still out there at issue, trial's basically over at this point. Also, the issue that one of the problems in the state's proof is that her version of the events was she comes home, they've had a great evening, everything was fine, she's walking her dog and she walks back in before they're going to go meet a friend, and she just gets attacked by him with no motive, with no reason, with no rationale, with no anything. So a juror has to have that question of whether or not, well, what happened there? That doesn't make any sense. When you get to put in the fact that, well, he's done it before, you kind of get to fill in some of the gaps if you're a juror and you're trying to look at what happened, and you get this, well, here's a conformity. This is what this person does. This is who this person is.
Was the testimony elicited on cross-examination?
No, it was...
Or an examination by defense counsel?
No, it was not.
It was in the state's case?
Yes.
What remedies did defense counsel request?
Requested mistrial.
Any other lesser remedy?
No, they went with, once again, a curative instruction, but that's not what was requested.
Okay. So the trial court gave a limiting instruction at the time?
Yes.
Did the trial court repeat the limiting instruction in the final instructions to the jury?
I don't recall that.
Was that requested?
I don't recall if it was done in the jury instruction or not.
Okay. All right. Yes.
I'll reserve the rest of the time.
All right, thank you. It's be several members of the defense bar in the courtroom at this time. Causes me to be reminded that to make an announcement that beginning in the May term, the court expects to start utilizing the timer. I started to say shot clock. It's sort of like that, I guess, but we're going to start utilizing that time. We need to wait till May to do that so we have time to install the trap door at the podium.
Does that apply to our side as well?
I think it does, yes.
I don't know that Mr. Whalen laughed about that, but everybody else did, Mr. Whalen. Anyway, no trap door, but you can expect, I think, beginning in the May term when you appear, that you'll be operating with the timer instead of me calling out minutes or whoever's presiding at the time. Very well. All right, I'm sorry to delay your argument. General, go right ahead.
Well, good morning, Your Honors, and may it please the court. My name is Alan Groves, and I'm here on behalf of the state of Tennessee. The defendant assaulted his fiancée by grabbing her hair and repeatedly slamming her head into the floor and then dragging her around the house by the hair. On appeal, the defendant, in his brief, has challenged the sufficiency of the evidence underlying his convictions, as well as these two motions, the denial of these two motions for a mistrial. He also identifies cumulative error and the length of his sentence as additional issues. And I mainly am going to limit my argument this morning to these two mistrial motions that have been addressed in defense counsel's opening argument.
General, before you get to that, can we pick up where your friend on the other side left off? With the testimony that is being offered on the examination by the state's lawyer, after the witness has been told not to reference the testimony. What's the state's view? Is the state's view that the curative instruction was sufficient to remove all prejudice here? Or was it a closer case than...
I just want to clarify, are you talking about the officer's testimony or the victim's testimony? The victim's testimony. So just to clarify the procedural posture of when that occurred, it wasn't during the state's case in chief, it was during the state's rebuttal, but it was during the examination of the state. So I think the easiest way to analyze this issue is just to apply the three factors that the court considers on a motion for a mistrial. So did the state elicit the testimony? Was there a curative instruction given? And then you consider the strength of the state's proof. And I don't think the defense counsel disputes that this testimony was not elicited by the state. The victim kind of gives this long-winded answer, and then towards the end starts saying, I don't know if I can say this, but he was deleting pictures of marks that he left on me previously.
Not to suggest argument for the appellant here, but I thought that where the appellant was going was that on the first prong, it essentially is being elicited by the state, but even if it's not, it's bad faith because the witness herself had been instructed not to reveal that information, and yet she does so anyway. State's witness acting in bad faith. If that's the argument, I'm not sure that it is, but if that's the argument, what's the response?
Yeah, I'm not sure that is what the defense counsel's
Let's say
arguing.
that it is. What's the response?
That the state or the trial court instructed the victim not to testify to this.
That the evidence is being offered in bad faith because the witness knows not to give the testimony because she's been previously ordered not to, and she's revealing it during her examination by the state's lawyer.
If that's the case, I think when you're considering the first prong of the analysis, that would cut against the state's position. But I think the record pretty clearly reflects that the victim's answer was non-responsive to the question. Her answer comes at the end of a long paragraph in the transcript, so she's kind of rambling as she's giving this answer. The transcript specifically does not reflect that the state somehow instructed her to give this. But I do acknowledge, Your Honor, if that was somehow supported by the record, that would cut against our position on the first prong.
The state's position is that's not supported by the record.
Correct, Your Honor.
The question was by the state, can you tell us exactly what was deleted? And then, as you say, she started sort of rambling, but it's clear she knew she was not supposed to go here because she says, I don't know if I can say this. And then she
I think
spits it
that
out.
reflects it's not clear because she doesn't know if she can say it.
I don't know that I can say this.
It at least reflects that she's not certain whether she's allowed to say it. There wasn't an objection at that moment. I recognize it wasn't too long after that she follows up with the challenge testimony. But there's certainly a question as to what the victim knew, but that could have just come from her common understanding of the trial process. I don't think that's sufficient to establish that the state somehow coached her to elicit this testimony.
Well, I'm really not suggesting that. It just seems to me that she had some knowledge that she wasn't supposed to go into this area, but yet she did.
And I'm not sure that would really be relevant unless it was the state that it was eliciting the testimony. I don't think it's sufficient that it just happened to occur during a direct examination during the state's rebuttal proof. There also wasn't a curative instruction given, and if I recall, the trial court offered the instruction and defense counsel accepted that it would be given. I also don't recall if the instruction was repeated, Judge Greenholtz, in the final jury instructions. That wasn't briefed. But another thing I need to emphasize, because it wasn't discussed at all so far this morning, is the state's proof was extremely strong in this case. There was overwhelming proof of the defendant's guilt. We had the victim that testified as to her account of the events. There was body camera video from the arresting officer who found her cowering in her neighbor's kitchen. He immediately took photographs of all of her injuries, and the injuries are extensive. There's several photographs in the record that Your Honors will be able to review, and a jury could easily conclude that those injuries were not sustained simply by the victim throwing herself up against a wall or running into a door. The defendant kind of gave contradictory accounts of what exactly she did. But there was overwhelming evidence of the defendant's guilt, and that factors into the third prong of both of these mistrial motions.
Wasn't there also, didn't the defendant take away her cell phone?
Yes,
also?
Your Honor.
And would that be some evidence that the defendant was acknowledging maybe that there was more of a role to play than?
I think so. And it also directly supports his conviction for interference with emergency communications. We've also argued that in addition to these factors that the court considers for the denial of a motion for mistrial, that the victim's testimony was actually admissible. Now, the trial court went ahead and excluded it just out of an abundance of caution, but even though the 404B procedures were not followed, this court has held that if the testimony is unsolicited, then the appellate court on de novo review can conduct a 404B analysis, just de novo. And so we've argued in our brief if the court wanted to analyze the issue in that manner, it could certainly find that the testimony was admissible, because although it implicates 404B, by referencing prior bad acts, it wasn't offered by the victim to establish the defendant's propensity for violence. She was actually just trying to give contextual background for the case to explain the defendant's motive, as you mentioned, Judge Greenholz, as to why the defendant had taken her phone, why he was deleting text messages.
Well, but I mean, to get there, under Gilliland's analysis, it's not just that it's offered for its context. There has to be a conceptual void in the proof, right? Such that the jury would not understand what was actually occurring. And this is not a Gilliland situation, is it?
I think there's two conceptual voids that were left by the initial proof. One is, why was the defendant taking her phone and deleting references to himself? I mean, without this testimony, you wouldn't know. There would be a void there. Another conceptual void is that the victim initially testified that he had deleted her phone, I think is the way she put it, or that the defendant put it on cross. And the defendant tried to capitalize on that and tried to portray that as inconsistent because the victim also admitted that there was at least one photograph of the defendant still on her phone from the restaurant earlier that evening. And so the defendant, when he chose to testify, kind of made it seem like she had contradicted herself. Like, either you deleted everything of me on your phone or you didn't. And so this also created a conceptual void that she was trying to explain. No, he didn't delete everything on my phone. It was just the marks that he left on me previously. Of course, I didn't delete just the picture of us at the restaurant earlier that evening. So I do think this exception to 404B is implicated. Now, the state would also have to prove that there was clear and convincing evidence that there was prior abuse, and we've argued that if you consider the whole record, at the sentencing hearing, the trial court heard extensive testimony from the victim about 4 specific occasions of prior abuse, and the court accredited the victim's testimony at the sentencing hearing. And so if the court had conducted a 404B hearing during the trial, there's no reason to think it would have reached a different credibility determination on that issue. So I do think, regardless of whether the court analyzes this under the 3 mistrial factors or conducts a de novo review under 404B, it clearly was not an abuse of discretion to deny the motion for a mistrial based on the victim's testimony. If there's no further questions about that issue, I can turn to Officer Johnson's testimony that the scratch marks appear to be self-inflicted. And just to begin, I want to clarify that the record, I've cited this bench conference that occurred when there's discussion about whether the officer should go into this or not. It's on page 16 and 17 of the state's brief. And it was suggested this morning, and I think in the reply brief, that the court specifically instructed Officer Johnson not to testify that these wounds did not appear to be self-inflicted. That's not really supported by the record. If you're reading it closely, the court is asking the prosecutor, were you even intending on asking him that? Were you going to go down that road? And she says, no, Your Honor, that's not particularly important to us. I wasn't going to go there. And so the court then directs to the prosecutor in a suggestion that, okay, you may want to rephrase the question and make sure that he just sticks to a visual description of the scratch marks. So it wasn't an instruction to Officer Johnson specifically. It was a suggestion to the prosecutor that if you're not going to go down that road, then maybe rephrase your question. And the state tries to do that and says, okay, can you try to describe the marks without anything further? And that's when the testimony comes out. They looked self-inflicted. And so I do think it's important to kind of put that in context a little bit to show that I don't think that necessarily shows bad faith on the officer if he still interpreted that rephrased question in a way that he thought he needed to give that testimony. But either way, if we look through the 3 mistrial factors again, each of these cuts in our favor. The state didn't elicit this testimony. It specifically rephrased the question to try to avoid that. And the defendant, again, doesn't really dispute here that the state had any bad faith here. There also was a curative jury instruction, and again, I think that was kind of the trial court just acting out of an abundance of caution. It didn't specifically rule that would have been inadmissible.
What exactly did he say? What were his words exactly?
Whose words, Your Honor?
The Officer Johnson's. About the self-inflicted nature of the scratches.
They looked self-inflicted.
They looked self-inflicted?
Yes.
In response to the question, how did the scratch marks on the body look? Asked by the prosecutor.
And the sentence right before that says, I guess without anything further. Just by telling us how they looked, I guess without anything further, how did the scratch marks on the body look? And so Officer Johnson was testifying based on his own perception of looking at the defendant's body. His shirt was off so he could see the scratch marks on him. And he concluded that he thought it looked self-inflicted. Now, when he initially says that, he's kind of just blurting that out, and there wasn't a lot of foundation laid at that time. But then he goes on to explain why he's saying that. And the record reflects that he's gesturing to the jury as he's describing exactly where the marks were. And it sounds like he's basically, demonstrating with his hands how someone could have made that gesture on themselves. And Judge Witt, as you mentioned earlier, there's photographs of these injuries on the defendant that the jury would have been able to observe. So to the extent that they disagreed with the officer's assessment, they could have, disregarded it just as easily. And I think that goes to any potential prejudice here. Again, there was an instruction given, so I think that also remedies the issue, and the state's proof was strong. But we definitely do not concede that the testimony itself was inadmissible. And there was some suggestion in the reply brief that we had conceded that at trial. And I just want to get on the record, volume 4, page 5 is where this issue comes up shortly before jury selection. And that's the point at which there was a discussion about whether the body camera video should be redacted to take out that statement. Because apparently the officer had made a very similar statement at the victim's house when he's arresting the defendant. And at that time, the state specifically argued that this is not expert medical testimony. It's just lay opinion testimony, and the trial court reserved its ruling on that at the time and just said, I'm going to exclude and redact the statement on the body camera video as hearsay, but we can address this other issue later at trial. And
how does the state explain the representations both by the prosecutor and by defense counsel on the motion for new trial, that the trial court had instructed the officer not to testify as to that fact?
I think the record just speaks for itself. The bench conference was recorded, and it's found in the transcript, and the transcript just doesn't reflect that the court directed any kind of command to the officer himself. So I think, the motion for new trial happened, several weeks or months after the trial, and the attorneys are basing this on their recollection. And I agree that it's a very similar situation. The court did make some kind of affirmative statement about whether they should get into this or not, but it was directed at the prosecutor in terms of asking her to rephrase the question. Again, without ruling on the underlying admissibility of the statement itself. So I think the record will speak for itself on that. Just the last couple of things I'll mention. It wasn't raised this morning, but the defendant has challenged sufficiency and cumulative error. We've argued that the cumulative error claim is waived, and in the reply brief, the defendant says, well, Rule 3 of the Rules of Appellate Procedure doesn't require a motion for new trial to be in writing, and maybe I raised cumulative error orally at the motion for new trial hearing, but Rule 33B of the Rules of Criminal Procedure does require a motion for new trial to be in writing, and it allows you to raise an issue orally at the hearing on the motion, but then it has to be reduced to writing within 30 days after the sentencing. So we do maintain that cumulative error is waived here. I didn't argue inadequate briefing on sufficiency of the evidence. I did note in my brief that the defendant didn't cite to any of the criminal statutes that he was convicted of or identify any of the elements that they were challenging. Kind of anticipating that might be addressed in the reply brief or at oral argument. The reply brief still did not address sufficiency of the evidence, and I still haven't heard anything about that this morning. I think the court could deem that issue waived if it chose to, but I'll rest on my brief for the merits of that issue and sentencing, unless the court has further questions. I respectfully ask the court to affirm the judgment of the trial court.
Your Honor, the state is responsible for their witnesses. They're responsible for their witnesses. This doesn't mean they always are able to control them, what they do or what they don't do, but they're responsible for their witnesses. The testimony was from the prosecutor that she had gone on over this with the victim in this case, not to bring these things up. They did not supply this as part of 404. This was not going to be an issue that the state had planned on, and we can surmise at what reason that might be, that they didn't think that it would come in, but that's not important. The important thing is she instructed her not to do that, but then asked the question, tell exactly what it was that was erased on that phone. So although counsel at the motion for new trial, the counsel for the defendant says that he wanted to reiterate that he was not attacking the actions of the prosecutor, the specific question was still asked about, to elicit it. So did the state kind of elicit that testimony? Yeah, I believe they did.
Would any limiting instruction have been appropriate to mitigate?
I'm sorry, I didn't hear.
No, I'm sorry. Would any limiting instruction, in your view, been appropriate to mitigate the harm that you allege, or is this an example, as you said, where...
You just can't fix it. And this is the problem when we're doing this and you're going through trial. The more you bring it up, the more power it receives. And the more that, because I have been faced with that issue multiple times, it's difficult to want to reiterate once time has gone by and want to reiterate and bring something back up that they were already supposed to have forgotten. It's tough to continue to do that.
So the law presumes, though, that the jury will follow the court's limiting instruction.
Of course.
Are you asking us not to apply the presumption?
No, I'm not doing that at all. I'm trying to say, don't check our common sense at the door.
I understand that part. Do you find any fault with the limiting instruction itself? Should it have been reworded?
No, I don't find fault with specific instruction. I'm just saying there are certain things you can't undo. There are certain bells you cannot unring. And in a case like this, where credibility was everything, you diminished the defendant right from the beginning on day one, and you did it again on day two. The state don't contend that it wasn't diminished. In their own brief, they said, yeah, it compromised his credibility. They just said not to the level of granting a mistrial.
Mr. Witt, what do you say in response to your friend's argument that the officer actually was not instructed not to bring up the opinion that the wounds were self-inflicted?
Well, not having been there, I can't tell you exactly. I can tell you what I think.
Well, he references the transcript from a pretrial hearing.
Right.
So,
and by looking at the transcripts, here's what I know, my experience of 32 years of doing this. You get a transcript, you get a bench conference, and the court reporter's there, and they do all that, and then all of a sudden the parties are walking back, and the judge can very easily say something that does not get included after the formal bench conference is done and before we start back up. Could very easily turn around and say, now don't do that or don't do this. I find it very compelling, however, that both the prosecutor and the defense attorney both argue in the motion for new trial that he was actually instructed by the court not to do that. I don't think they would have made that argument, both of them, if it had not actually been done.
Mr. Witt, I just wanted to follow up on an argument that the general made. It does seem in your brief that you're not relying too heavily on issue number 3, the sufficiency of the evidence, because as you've said, this was a he said, she said, and the jury obviously believed her over your client. Would you agree with me on that?
Yes.
Are you still pursuing the sufficiency of the evidence issue?
Of course.
Okay.
Of course we still pursue all of them. We obviously have a limited amount of time. And
well, I've seen lawyers at oral argument concede before, so I thought it was worth a shot.
Oh,
okay.
No, I'm not conceding that at all.
All right.
I think my time's up. Thank you.
All right, thank you. Thank you both for your argument presented today. Call of this case, please.